Good afternoon, everybody. I would like to thank the National Indian Education Association for inviting me here today to talk about DRNY, the Protection Advocacy System for individuals with disabilities, the rights of students with disabilities, and the services available for students with disabilities as they transition to adulthood. I would also like to thank you all for taking the time out of your busy schedules to listen to my presentation. My name is William Tronsor, and I'm a staff attorney here at Disability Rights in New York. Licensed to practice law in New York and at the federal level. I did try and keep a lot of this information general, but there may be some differences depending upon the state you are in. So it's always good to try and be informed about the particular laws in the state that you're in, if you're really looking to be the best advocate for your child or someone else who you are trying to assist. At the end of this presentation, I will provide you all with my contact information. So feel free to reach out to me by email or by giving me a call if you have any questions about this presentation or really anything else. So let's just jump right into it. So the first question you probably have is, what is Disability Rights New York? Disability Rights New York is a nonprofit organization. We protect the civil and legal rights of all New Yorkers with disabilities. Our purpose is to ensure that all individuals with disabilities are treated equally with dignity and respect. We hope to create an inclusive world, one that provides an equal opportunity for individuals with disabilities and one that is free from discrimination, abuse, and neglect. In an ideal world, if we were able to reach our goals, our services would no longer be needed. Now, DRNY is part of the overall protection advocacy system for individuals with disabilities in the country. And I'm just going to show you a really quick, short video that I hope you all enjoy about, what we are here at Disability Rights New York.
Did you know there is a nationwide advocacy system to protect people with disabilities, and that it was created right here in New York State? Abuse and neglect of people with disabilities is a dark stain on our national and state history. The exposure of Willowbrook in 1972 was the catalyst for the disability rights movement, initiating several acts and programs into legislation. By 2013, Disability Rights New York was designated as New York's Protection and Advocacy System and Client Assistance Program. What do we do? DRNY is a private nonprofit that provides free legal and advocacy services to individuals with disabilities, both seen and unseen. We have the unique authority to monitor programs that deliver services and investigate allegations of abuse and neglect. As the only organization with this authority in New York State, our goal is to help our clients exercise their own life choices and fully participate in community life. How are we different? There are many organizations undertaking disability advocacy in New York State. However, we are the only organization designated by Congress to identify rights violations and advocate for systemic solutions. We are not a state agency, nor are we a part of the government. But we do fight to give a voice for those who are hidden, abused, and neglected throughout the state. Under the following programs: CAP, PAT, PABS, PAD, PAMI, PAIR, PARP, PATB, and PAVA, DRNY works to address discrimination affecting New Yorkers. If you want to learn more about DRNY, please visit our website, www.drny.org, and follow us on our social media platforms.
Now, I'm just going to flesh that out a little bit more for all of you. DRNY is part of the overall protection and advocacy system for individuals with disabilities that was created as the result of an expose on the Willowbrook School in Staten Island back in the 1970s. The conditions these individuals with intellectual and developmental disabilities were being kept in Willowbrook was so shocking that it started a national conversation about the need for better support and services for individuals and better protections for individuals with intellectual and developmental disabilities. This national conversation resulted in Congress passing the Developmental Disabilities Assistance and Bill of Rights Act in 1975, which we refer to here as the DD Act. The DD Act, what the DD Act did was it offered states federal funds to protect the developmentally disabled if they created a protection advocacy system for individuals with disabilities, or if they designated a nonprofit to protect and advocate for individuals with disabilities. Now, originally, the P&A systems could only advocate for individuals with intellectual and developmental disabilities. But over the years, Congress has passed numerous statutes with additional funding. So now, if you're an individual with a disability and you have a legal issue, any disability, and you have a legal issue related to your disability, you likely can be receive services from the P&A that's in your state. Now, today, there's a P&A, a protection advocacy system, in every state and U.S. territory, as well as there's actually one that specifically serves the Native American population, covering a couple of states in the Four Corners region of the U.S. There are 57 P&As in total. Most of the P&A systems are nonprofits. There are 7 that are still state-run agencies. Each P&A system is its own entity, like DRNY is nonprofit. The other P&As are their own thing, but collectively, collectively all of the P&As are the largest provider of legal-based advocacy for individuals with disabilities throughout the country. Now, if you're looking to find the P&A and CAP provider, which stands for Client Assistance Program, in your state, you can go to the link that I've attached to this slide. Just put in your state's information and where it needs to just put in your state's information where it tells you to, and then it'll provide you with the information for the P&A program in your state, and then you can reach out to them for assistance. Now, I just want to say each P&A system is different, but so what they can and cannot do vary slightly, but generally speaking, here is how P&A systems support people with disabilities. One of the ways is that they provide direct legal representation. They provide free direct legal representation to individuals with disabilities under all federal, state, and local laws and regulations for legal issues relating to their disability. They will pursue mediation, negotiation, administrative, and really any other appropriate advocacy to further the civil rights of individuals with disabilities. P&A systems also provide a lot of technical assistance. So if an individual reaches out, they will advise individuals of their rights under various laws and how they can enforce their own rights through self-advocacy. P&A systems also provide a lot of systemic advocacy. Will gather data and conduct investigations based on issues that appear to be impacting groups of individuals. For example, we'll do investigations of group homes, prisons, schools, or really any other location based on multiple complaints of abuse or neglect. And we'll issue reports on systemic issues to policymakers and to the public in the hopes to make systemic change to the issues that we found through our investigation. We do a lot of education, educating and informing the public about issues that may be impacting the disability community. But we also will provide information to policymakers and provide comments on proposed policies that may impact large numbers of individuals with disabilities, and explain to them how these policies may impact those individuals. We do a lot of outreach. P&A systems overall do a lot of outreach, kind of like I'm doing here today to inform about DRNY, P&A system, and special education law. But P&A systems also do more specifically tailored trainings, which we call Know Your Rights trainings, on specific areas of the law, such as special education, accessibility, employment discrimination, the reasonable accommodation workplace, and the list could go on and on. We can also do trainings on a particular topic if you reach out to us about it and give us enough advanced notice. We also provide P&A systems provide a lot of information and referrals. We connect individuals with resources and groups to address concerns that they have when they reach out to us. For example, here at DRNY, our intake team really prides themselves on doing the best they can to help everyone. What I mean by that is if you contact your intake department, they're going to do the best they can to listen to what your issue are and try and figure out the best way that we can assist you. Does that mean that everyone is going to get an advocate or a lawyer? No, but if it's not something that's in our wheelhouse, they'll try and determine what the issue is and then hopefully put you in contact with an organization that may be able to help you with your issue if it's not something that's particularly in our wheelhouse and something that we can help with. Now that you have an idea of how P&A system, how they actually support individuals with disabilities, I'm going to give you a general idea of all the areas in which they support people with disabilities. So P&A systems support people with disabilities in a range of areas, one of them being education. P&A systems can help students with disabilities to get the services that they are entitled to under the law. And that could be anything from the beginning of the process where a parent thinks their child has a disability and may need special education service, or a situation where the student already has an individualized education plan or a 504 plan, which I'll talk about in a little bit. And the school isn't implementing them appropriately. P&A systems also do their best to ensure that students are educated in the least restrictive environment. And P&A systems can look at more systemic issues in schools if there are particular policies that are impacting students with disabilities. Another area that we assist with is transitioning to adulthood. And what I mean by transitioning to adult is simply put, just assisting students as they, are moving from their high school or graduating from high school into the workforce or to higher education. And that's what I mean by that. So P&A can help individuals basically transition from school to their employment or to higher education. And I'll get into more detail about that a little bit later in this presentation. Another area P&A systems can assist with is employment. P&As can help persons denied reasonable accommodations requests in the workplace, or if an individual with a disability was discriminated against because of their disability at any stage in the employment process, whether it occurs during the application process while they're working, or if the discrimination is the reason that they think they may not be getting a promotion and they've worked at a place for a while. Another area that we assist people with is P&A systems assist people with is independent living. P&A systems advocate for people to be able to live independently. We advocate for individuals to have the support they need to live independently in the community, and so that they have the same freedom of choice as their non-disabled peers. We also assist with access to services. P&As can help individuals who cannot access certain buildings or public places that are not in compliance with the ADA. We can ensure that the services being offered, provided by public and private agencies, are accessible to you. P&A systems also do a large amount of investigations and monitoring of schools, hospitals, nursing homes, prisons, and really any place that's provided federal funds and providing services to individuals with disabilities to ensure that individuals in those facilities don't experience the same abuse and neglect that occurred in Willowbrook back in the 1970s. Now that I've talked about the P&A system and DRNY, I'm going to switch gears and give you all a brief overview of special education law and the rights of students with disabilities. So there are two main laws that govern special education services in the US. Section 504 of the Rehabilitation Act and the Individuals with Disabilities Education Act. Both of these acts are federal laws, so they create a floor for special education services throughout the country. What I mean by that is that states can do more to protect and provide services to students with disabilities, but they cannot provide less support and services than what these statutes require. So for example, in New York State, there are actually some laws that provide extra protections for individuals with disabilities related to education. But like most states, these are the two statutes that are the main laws relating to special education in New York. The reason I mention that is because it really is important for you to try and learn, the laws in your state and your local laws to see if there are any additional protections that there are, so that you can be the best advocate for the individuals you're trying to assist. Now, the IDEA and Section 504 have different protections for students with disabilities. So let's talk about these protections and what these statutes actually provide. Section 504 of the Rehabilitation Act states that no otherwise qualified individual with a disability shall solely by reason of his or her disability be excluded from the participation in, be denied the benefits of, or be subjected to discrimination under any program or activity receiving federal financial assistance. You're probably thinking, great, but what does that mean? Generally speaking, that means a district must accommodate a student with a disability so the student has equal access to the school's programs, events, and activities in the same way as his or her peers without disabilities. Basically, school programs and events and activities must be accessible to all students with disabilities. That could be an after-school thing, something going on in the auditorium, and just going on in the classroom. They need to be able to access their education. Schools must provide the supports and services, and the way they do that is by providing accommodations that are necessary for the student to be able to participate equally in their school program. And as I said, Section 504's requirements extend, to all individuals with disabilities in any kind of program or event or activity going on with the school. So how is a student actually provided equal and non-discriminatory access? I mentioned this already, but it's accommodations that the student is provided with the supports and services that they need to allow the student with a disability to access the school's program. The accommodations that students are provided must be based on the student's needs, and they must not fundamentally change the school's activities, programs, events, or activities. Accommodations that a student receives under a 504 plan, and I'll talk about that in a minute, must be based, as I said, on their particular needs. Now, Section 504 requirements, as I said, extend to all individuals with disabilities, including students who are actually going to be covered under the IDEA. And I'll talk more about that in a bit. And Section 504 requirements to accommodate students with disabilities extend beyond just the classroom setting, and that's important to remember. Under Section 504, schools must accommodate students in non-academic settings, such as lunchrooms and libraries, and for school activities such as assemblies, graduations, field trips, and after-school programs offered by the school. For example, if there is a school that is taking a class trip to a museum and there's an individual who's a part of that class who has a mobility disability and uses a wheelchair, the school is going to need to, and they've decided that students are going to get to the museum by bus. The school needs to make sure that there's a way for that student in a wheelchair to go on the field trip with his or her non-disabled classmates and accommodate them so that they can do that. So if a student needs, an accommodation to have equal access to schools, programs or activities, then the district is going to need to create what's called a 504 plan. A 504 plan is a document describing how the student's disability impacts participation in school and the specific accommodations the school must provide. A 504 plan is developed by a team that includes the parents. There are a ton of different examples of accommodations, but as I said, the most commonly used example to kind of put this in perspective is a student who needs an accommodation to gain equal access is an individual with a mobility impairment, for example, who may be in a wheelchair. that needs to gain access into the school. Say, for example, so the school would need to either provide a ramp for that child to get into the building, or, an elevator in some places that lets them know so that they're able to get in and actually access their school. As you can see from that example, 504 accommodations does not have to necessarily have an effect on their actual education performance. It's really just that the student needs an accommodation so that they can have an equal opportunity to participate in school. Other common accommodations under Section 504 are services based on a student's medical needs, like a student who is diabetic and may need additional snacks or breaks to go to the nurse to administer insulin, preferred seating, verbal, visual, or technology aids. For example, a student who's deaf may need what's called an FM system so that they can, hear what their teacher is conveying to them, giving them access to their education. Extended time for tests and assignments, access to a service animal, and that list could, go on and on. It's not an exhaustive list. Now that we've talked about Section 504, let's discuss the IDEA. The IDEA was written to ensure that children with disabilities have available to them a free, appropriate public education. The goal of the IDEA when it was written was that if we have schools really invest in students with disabilities now, while they're in school and provide them with the supports that they need now, they'll be much better off later on in the rest of their life. And that is absolutely true. If a school provides a student with a disability with a special education and related services they need to meet their unique needs, as they're required to under the IDEA, that student will be much better off in the future as they'll have had an appropriate education that would have prepared them for employment, secondary education, and independent living. What you're probably thinking though right now is, what is free, appropriate public education actually mean? So the F in free, appropriate public education means free. It means that the special education and related services that the student receives from the district are at no cost to the parent. A means that your child with a disability is entitled to an education that is appropriate for them. I'm going to talk a little bit more about this one and go into a little bit more detail. A district must provide personalized instruction supports and services that allow a child with a disability to benefit educationally from instruction. So the IDEA is for students whose disability is having an impact on their education. Now, an educational program must be reasonably calculated to enable that child to make progress in light of their disabilities. So simply put, what that all means is that when there is a student with a disability whose disability is having a negative impact on their education, the school is, required to put tailored services and supports in place for that student to meet their unique needs. When that occurs, the school needs to put in place an individualized education plan for the student. The services must be based on their unique needs, and every student with a disability's needs are different. They're very individualized. And money is not supposed to be a factor that's taken into account when deciding what's, appropriate for a student. The reality is that it does. But one note that I do want to make is that a school's inability to provide a service because of a lack of providers is not a legal justification for them not providing, reducing, or ending an appropriate service. So say, for example, someone is supposed to be receiving occupational therapy and they had an OT provider, but that person left and they don't have one. If they don't provide services to that child while they were supposed to be being provided, they'd be entitled to what's called compensatory services, which is makeup services for the time they miss those services. So some examples of appropriate related services may be speech language pathology, audiology services, psychological services, physical and occupational therapy, counseling services, orientation and mobility services, resource room health services, and honestly, that list could also go on and on. So we're going to move on then to P in FAPE, which is for public, the fact that children are entitled to go to a public school. NE that refers to the fact that every eligible school, a child must be provided with an education. Now, the IDEA also has a requirement that students with disabilities must be educated in the least restrictive environment. And what that means is that students with disabilities must be educated in the general education setting with their non-disabled peers to the maximum extent appropriate. The school must try all appropriate supports before segregating a student, away from their disabled peers. Students with disabilities should not be placed in special classes, separate schools, or otherwise removed from the regular education classroom, unless the nature or severity of their disability is such that even with appropriate supplementary aids and services and program modifications and accommodations, that their education cannot be satisfactorily achieved. So school is basically supposed to try, kind of almost everything before the student is placed in a more restrictive setting. And that's what it means to be educated in the least restrictive environment. So there are additional requirements by the IDEA and what FAPE means. So there are some substantive requirements. So if your child is determined eligible to receive, services, under the IDEA because of their disability and how it's impacting their education, the district is going to need to create an individualized education program, an IEP. It's a written document created by the Committee on Special Education, and the Committee on Special Education includes parents. And the IEP is a written document, and it lays out the student's needs, whatever they may be, academic, social, behavioral, kind of what the issues are. It also has measurable annual goals related to the student's needs that may be interfering with their learning. For example, if there's a student who has a reading disability, maybe dyslexia, they might have a goal that they'll be able to read, a paragraph by a certain amount of time, or a couple of lines by a certain amount of time, and kind of things like that, just to give you an idea of what I mean by measurable annual goals. Services in program or placement, school will be provided, and what I mean by that is they just need to list what the individual's services are, what their program is going to be in their placement. So say if there is a child that needs to be moved, in a smaller classroom setting, it'll list that they're in a 1211 or 811 or something along those lines. It'll also list any other services that they need. If they need speech, language therapy, or whatever it is, it'll list that in their IEP, what their related services and accommodations are. It'll also, as I said, list their accommodations, such as test taking in separate settings, assistive technology, reduced homework breaks, whatever else their accommodations may be. And the student must receive an educational benefit and make progress towards their IEP goals. And that's kind of how it's measured. So you have these goals, and if they're making progress towards the goals in their IEP, then we know that they're benefiting educationally from their education. The best way to think about an IEP is that it's a contract between you and the school for the services and accommodations that are appropriate for your child or the child that you're trying to support, that they must provide. If they don't provide the services in your child's IEP, your child is actually entitled to, as I said something before, compensatory education, which is just make up services for the services that they're entitled to that they missed. There are also a number of procedural requirements under the IDEA. There are a number of different procedures schools must follow, and one of them is determining eligibility. Under the IDEA, districts are required to identify and evaluate children suspected of having a disabilities whose families live in the district. You may have heard this called child find before. They had this affirmative duty to try and find individuals who need, essentially these services. Schools are required to evaluate all areas of suspected disability, be that academic, behavioral, physical, social issue, and or delays that your child is experiencing that may be impacting their education. The school district must obtain parental consent before evaluating a child to determine that they need special education services. If you believe your child needs special education services and the school has not provided anything to them, you should make a written referral to your school's Committee on Special Education, describing all your areas of concern. Because as I said, they have to evaluate all of them. So get down all of your areas of concern, be that academic, behavioral, whatever it may be. Now, they also need to provide notice when providing or changing services for a student with a disability. The school must give the parent or guardian written notice. Written notice is just a written statement provided to you a reasonable time before the school district proposes to or refuses to initiate change of placement or evaluation or anything kind of like that that may be or may not be appropriate for your child. They also need to ensure that parents, guardians, and students are involved in special education decisions. That includes involving you and the Committee on Special Education, needing to determine if your child needs special education services. If they do not need special education services, then you must also, if they do need special education service, you must also be included as an equal partner at the CSC meeting, and that there are ways that you can challenge them if they think that they don't need special education services and you believe that they do. And that leads us into the next procedure, that there must be no cost ways for parents and guardians to challenge decisions made by districts. And I'm going to give you just a number of ways that you can challenge decisions made by districts. One is if you disagree with an evaluation or the decision made by a CSC, you can request what's called an independent educational evaluation. An IEE is an independent evaluation paid for by the school district where the parent selects a qualified examiner who does, the evaluation for the district or other public, agency that's responsible for educating your child. You must make the request in writing, and the school district, must pay for the entire evaluation so long as the fee charged by the independent evaluator is consistent with a qualified evaluator, and basically the charge is basically the same as in your geographic area. They're not charging something super high, that it is just the regular cost for someone providing that evaluation in your geographic area. They can't really place a cap on the cost if it's less than the going rate in your area. They can't place a cap that's less than the going rate in your area. Mediation is another potential option that you can take if you disagree with a decision made by a district. Mediation is where an impartial mediator, basically a third party who is trained in effective mediation techniques and is knowledgeable about the laws relating to special education, sits down, with you and the district and listens to what you have to say, what the district has to say, and you both kind of come up with an agreement that you're both happy with. Mediation is free and voluntary on the part of the parent. So that's one of the ways that you could potentially, challenge if you disagree. Another way is you could go to an impartial hearing. An impartial hearing is a formal legal process where the disagreements between you and the school district are presented to an independent hearing officer. Independent hearing officer can be held, an independent hearing can be held regarding any matters related to the identification, evaluation, or educational placement of your child, or any provision of a free appropriate public education. The hearing itself is free, but if you would like an attorney or an advocate to represent you, you'll likely have to pay for that advocate or attorney to represent you. Now, P&A systems do offer free legal services to individuals with disabilities. So you could reach out to your P&A system and they may be able to help you. But one other thing I do want to mention is that if you do say go to just, an outside attorney that's not part of a P&A system, just for legal representation, advocate or an advocate, if you win, if you win and you had hired an attorney, you're, entitled to reimbursement of attorney's fees for the cost of the attorney's fees that you paid. And you're entitled to those fees unless the school district obviously wins the case or you win and they appeal and then you lose. So if you win the case, then you're entitled to attorney's fees. Now, there may be other avenues that you can take to challenge a district where you disagree with the decision that they're making in your state. So it's always good to see what's available in your state as another avenue. Additional avenue here in New York, for example, is you can make a complaint to the New York State Education Department. Basically, you would put your complaint in writing to the New York State Education Department. It's a free option, and New York State Ed will do an investigation and issue a written decision that addresses each of the allegations that you make in your complaint. If correction action is required, meaning that the school, you were right, your complaint was right, and the school messed up or was wrong, they'll issue a letter of resolution that basically says specifically the actions that the school needs to do to take corrective actions and how long the school has to correct a mistake or a violation. So if it's always good to look at, what's going on in your state, as there may be other avenues for recourse. And this is also not an exhaustive list of other things you can do. So if you do run across an issue, I would always recommend reaching out to an advocate or attorney who might be able to give you a better idea of all of your options. Here, I'm going to do a quick comparison of the two laws that I've talked about, so that you all have a better understanding of the differences between the two of them. To receive services under the IDEA, a student with a disability must fall into one of these 13 disability categories. I didn't actually include them here because honestly, it's not all that important in my time in practicing. There's never been an issue where someone isn't going to receive services because they don't fall into one of the 13 categories, or at least it hasn't come up where they don't fall into one of the 13 categories. If your child has a disability that's having an adverse impact on their education, they are likely going to fall into one of the 13 disability categories. To receive services, they need to fall into one of these 13 disability categories. Their disability needs to be having an adverse impact on their educational performance, and that they require specialized instruction or related services to benefit from instruction. And the standard, again, for the IDEA, remember it's related to education and everything like that, is the appropriate standard. So whether that service or related services support is appropriate for that student. So one thing I want to mention at CSE meetings, you may want to, some people are inclined, and parents and advocates say, hey, this is what's best for my child. My child needs this, or my child needs that because this is what's best. I would advise you to refrain from doing that because the standard is appropriate. So the minute you start talking about best, the district is going to respond to you, well, that's not the standard, it's what's appropriate. So when you're trying to convey that your child needs this appropriate, related service or support, it's, hey, this is appropriate for the student and here's why, not this is what's best for that student and here's why. So just remember that. Now, to receive services under Section 504, the student needs to have a physical or mental impairment that substantially limits major life activity. Major life activities include things like eating, sleeping, standing, lifting, bending, reading, concentrating, thinking, communicating. Those are just a couple of examples, and the list can go on and on. A physical or mental impairment that substantially limits a major life activity was intentionally, made as like a low bar by Congress so that it covers more people. It encompasses a lot of people. So it's a really low bar. So it covers a vast number of people. And the student, and to have a 504 plan, the student requires accommodations, supports, and or services to gain comparable access to the district's programs or services as their non-disabled peers. And the standard for Section 504 is a reasonable standard. Now, one additional thing, I just want to remind you all about Section 504 is that it doesn't just apply to education. It's about those additional things going on in the school, after school programs, and things going on in the auditorium, and they all, or field trips, like all those things. Students need to be accommodated so they have equal access and opportunities to participate in those other programs. Now, students with disabilities also have additional protections when it comes to discipline, and when it comes to suspensions and other disciplinary actions that can be taken by the district that take them out of the regular education setting. So if a child with a disability is suspended for more than 10 days, it's considered a change in placement is said to have occurred, and the school must hold what's called a manifestation determination meeting or review. This 10-day limit that I'm talking about does not have to be reached by a single suspension. So it doesn't just have to be that something occurred and the child is suspended for, say, 11 days or 12 days. It could be that your child was suspended multiple times during a time period for very similar, for very similar reasons. So think of, something happens here, they're suspended for 4 days. Something happens over here, they're suspended for 3 days. Something happens over here, they're suspended for 5 days. You can add those all together, and cumulatively, if it's over 10, that would also be considered a change in placement. So it's either there is a suspension for more than 10 days, like outright, that it's 12 or 13 days, or a number of different suspensions that cumulatively together are greater than 10 days, then it's considered a change in placement, and they have to conduct a manifestation determination meeting. A manifestation determination meeting is, held to decide, whether there is a relationship between the student's disability and the behavior that resulted in the disciplinary action. So generally speaking, and there are exceptions to this, but if there is a relationship between the student's disability and the behavior that resulted in the disciplinary action, they should not be disciplined for it. I think we can all agree that we don't want to be disciplining individuals for things that are related to their disability. So if conduct must be found to be a manifestation, essentially caused by the child's disability, if the conduct in question was caused by or had a direct and substantial relationship to the child's disability, or the district in question, or the conduct in question was caused by the district's failure to follow the child's IEP appropriately. Now, if the conduct is determined to be a manifestation of their disability, the district must either conduct what's called a functional behavior assessment, had the district already been working on what's called an FBA, a functional behavior assessment. They just need to continue it and implement the BIP that they were working on. Or if the child already has a behavior intervention plan, a BIP, they must modify the child's behavior intervention plan as necessary to essentially address the behavior. So hopefully these actions don't happen again in the future. And they must return the child to their original placement. Now, there are some, exceptions to that, and I'll talk about that in a second. But what a functional behavior assessment is, it's a research-based process of determining whether a student has a challenging behavior. It focuses on data, and it gets inputs from teachers, parents, and the student to look at what might be the causes and triggers of these actions taken by the student that are resulting in discipline. Is it something with a classroom environment or demands that are being placed on the student? So they're trying to get to the bottom of what is causing the student. So they'll look at things like, okay, let me take a look at this child's schedule. Oh, would you look at that? These actions which are resulting in suspension are always happening in math class. That's strange. It's not happening in any of the other classes. Let's go monitor that class. What's going on in that class that might be causing the student to act up? Then it'll result that FBA will be taken, and they'll create what's called a behavior intervention plan, which is a written document that is based, as I said, on the FBA, that I then identify strategies to address the behavior. So if they realize, oh, these particular things are triggers, what can we do for this student to reduce the amount of times that these triggers can happen, or what can we do to them, for them, or provide to them so that they aren't being triggered as much. And then everyone benefits and they're remaining in classroom and these instances aren't happening and they're continuing to be educated and hopefully not being suspended and taken out of the classroom setting. So the BIP is to really try and address the behaviors so that they don't keep happening. Now, as I said, if it is a manifestation, they do need to return the child to their placement unless the parent and the district agree that, hey, maybe this isn't the right placement for the child, and then they can move them to a different placement. Or if the child has inflicted serious bodily injury or was in the possession of a weapon or knowingly possessed or used illegal drugs. Now, I wanted to give you all a visual representation. I'm a bit of a visual learner myself of kind of how these laws kind of work together, Section 504 and the IDEA, before I move on. So on this graphic, you'll see a big circle that's gray, and that encompasses all students within the district. And these are, and as it gets in it talks about different students, but it encompasses all students within the district who are being educated. Now, that gray sliver that's on the outside and is thin represents those students who, and there's a small, minority of these students that are just straight A students. They just always get it. They're always getting A's. They're always doing great in school. They don't need any additional supports or anything like that. That's great, for them and everything like that. But that's who that gray sliver represents, those students who are just, kind of straight A students. The next circle, the blue, is students, with some difficulties who are just being served in the regular education setting. People are people. And this is, probably the biggest grouping of students that I'm going to talk about where, maybe they're just, they're better at English and science, but they're not so great at math and history, or, whatever it is. We all have our strengths and weaknesses, but these students are just struggling maybe, for example, in a subject or two, and all they really need is a little additional help, maybe some extra supports after school or things like that. But they don't need an accommodation like an accommodation under a 504 plan or under the IDEA. They just need a little bit of additional supports, and they're fine being served without a 504 plan or an IEP. The next smaller group is students who have a 504 plan, and as we already know, those are students who just need equal access to the services, and supports in the school, like that student who may be in a wheelchair who needs equal access to get in and out of the building, be that a ramp or an elevator. And then but that their disability isn't actually impacting their education. Then there are students, those IDEA students who are even within that group who have an IEP, whose disability is having an impact on their education, and they need those specifically tailored services to benefit, from their education, to really receive their free appropriate public education. Now, those students do fall within the same circle within that Section 504 students. So say, for example, if there's an after-school program or activity or something, and they want to be a part of it and their disability could impact them, they need to be accommodated too. But I'm hoping that that gives you a little bit of a view of a visual representation of how these two statutes kind of interplay and education generally, and where it might be right for someone to have a 504 plan or an IEP. Now that we talked a lot about special education, let's talk about the supports for students with disabilities as they transition to work or higher education. So the way that students with disabilities are really assisted in their transition. I mean, there are things that the districts have to be doing for a transition plan. But the main thing that happens during a transition is they're assisted by state vocational rehabilitation agencies. And state VR agencies are actually funded by the Related Service Administration, and they provide grant funding to these, agencies. Each state is set up a little different, but the services these agencies can provide are similar, and the list of state agencies providing vocational rehabilitation services can be found at the link that I provided in this email. I also just would like to mention that there are tribal VR programs throughout the country, which provide basically the same thing as the VR agencies, but they do it in a culturally competent way. And they serve Native Americans with disabilities who reside on or near federal or state reservations. For example, here actually in New York, there are two nations with TVR programs, the Seneca Nation and the St. Regis Mohawk Tribe, who are doing a great job at providing VR services to the communities that they serve. You're probably thinking now, though, that's all great, but what do VR agencies actually provide? Now, the services that VR agencies can provide vary a little bit, but generally speaking, they are the same. So I'm going to use New York's VR agencies as an example, as what they can do, but do know that they are a little different, but they generally can provide the same things in other states. So you just need to find out what the VR agencies are in your state. So there are two state VR agencies in New York, not including the two TVR programs I just mentioned, it's St. Regis and Seneca Nation, but there are two state VR agencies in New York. One is Access VR, and the other is the New York State Commission for the Blind. So Access VR is a state agency that helps individuals with disabilities to choose, train for, and find suitable employment. Access VR can work with most people with disabilities, but there is one exception. Access VR cannot work with individuals who are legally blind. Those individuals receive their services specifically from the New York State Commission for the Blind. The services that Access VR and the New York State Commission for the Blind are essentially, the same. It's just the difference is really just who they serve. So you're probably thinking, how do they help? So remember, Access VR and other VR service providers can provide services that are needed to assist with reaching employment. They can help individuals in obtaining what you need to prepare for, obtain or maintain employment. Now, you need to have a documented medical disability or something like that in order to receive service from a VR agency. But normally, if you have 504 or an IEP, that kind of works as qualifications, generally speaking. Now, Access VR and the New York State Commission for the Blind role in your employment search is to assist you in choosing, planning for, and coordinating the required services to reach your employment goals. Now, not all, no single service is guaranteed to the person, and all are determined on a case-by-case basis. But there are a good amount of services VR agencies can provide. They can provide assessments to determine an appropriate work goal, career counseling, guidance, college tuition, and also funding for books and other things like that related to college, or training costs and related books, tools, etc., and other things to really assist you in being gainfully employed or moving up to higher education. They can also help with job placement services. They can provide you with this technology. They can assist with transportation, vehicle modifications, if that's a barrier to getting to and from work. They can help prepare you for interviews and connect you with other employment-related service organizations. So you might be thinking, where do P&A systems and CAP programs fall into this mix? So P&A and CAP programs, specifically client assistance programs, can help you navigate VR agencies at every step of the way, whether you're just applying or whether you were denied a service from a VR agency that you think you should have been able to receive. And they can help you appeal decisions made by your VR counselors. And they can also, just fix the communication if there's just a communication barrier. Sometimes, people just lose touch with each other and reconnect you so that you can get the services you need to work towards your end. Now, we've reached the conclusion of this presentation today. I hope you all found this information helpful. If you're in New York and you need DRNY's assistance, you can contact our intake staff by phone or email. You can also submit an intake request directly on our website. Our intake staff is available from Monday through Friday, 9 a.m. to 5 p.m. Eastern Standard Time. And all the services that we provide are free of charge, and we keep all of our information confidential. If you are interested in a P&A system in a different state, if you live in a different state and you need help from your P&A system and you think you may benefit from their services, look them up at the link that I put in the earlier in this presentation. Just put your information in and it'll pull up that system's contact information, reach out to them and see if they can potentially assist you. Now, attached to this last slide is my information. Feel free to reach out to me if you have any follow-up questions about this presentation or anything contained in it. If you're interested in learning more about special education, in the materials after this slide, I have listed common questions and answers related to special education. I hope the additional slides are helpful to you. I didn't talk about them due to time constraints, but if you want to learn more, it's a great place to go. And it might actually answer some common questions that you have after watching this presentation. So thank you so much for watching this presentation. I hope you have a wonderful rest of your day and a wonderful rest of the time at your conference. Goodbye.